On June 2, 2017, I created a 6-hour-long documentary video, Corruption in America and What We Can Do About It. This was the culmination of many years of dealing with corrupt government. During that documentary, I went into an exorbitant amount of detail on all levels of corruption across all levels of government. I cited statistics rather than biased opinions whenever statistics were available, and I provided over 100 different sources to back up my claims. If you haven't seen that documentary yet, I highly recommend you watch it, as it provides an awe-inspiring look into just how corrupt the government is. Anyway, during Section 2-2 of that documentary, I addressed the legal doctrine of judicial immunity. In one section of that, section, I mentioned how government attempted to justify this draconian law by saying that it was necessary to protect judges from intimidation. I then went on to argue that there were 3 major flaws with this justification: a lack of clarity, a lack of evidence, and a lack of consistency. Today, I wish to elaborate on the flaw that their argument lacks clarity. In the documentary, I argued that nobody had ever even attempted to clarify just what type of intimidation they were trying to protect judges from. This is an important flaw, since as I demonstrated in that section, not all types of intimidation are necessarily bad. Well, I never stopped looking for more evidence of corruption, so I did a little research after uploading that video. I found that there was indeed a proponent of judicial immunity out there that has attempted to articulate a specific type of intimidation that judges would suffer if judicial immunity were revoked. In 2006, a voter initiative called the Judicial Accountability Initiative Law was proposed to the voters of the state of South Dakota. It was known at the time as Amendment E, and sought to remove judicial immunity, though it did nothing to fight corruption in other branches of government. The South Dakota State Legislature passed a resolution begging the people of the state to reject this initiative. The proponents of the initiative, an organization headquartered in Los Angeles, California, by the name of Jail for Judges, argue that the initiative was never even placed on the ballot in the first place for the voters to accept or reject, although since I was not in South Dakota at the time, I have no real evidence of that aside from the proponent's uncorroborated word. But that's not what I want to talk about today. I want to talk about what the South Dakota State Legislature actually said in the resolution they passed. In this resolution, they made a variety of comments about what kind of people can be subjected to suit. For the majority of these comments, my previous counter-arguments still apply. How is this a bad thing? How is holding government accountable even remotely a bad thing? However, there is one section in this resolution where the South Dakota Legislature articulated a consequence that is actually bad. In Section 8 of this resolution, the South Dakota Legislature says, "Whereas the author of Amendment E has publicly stated that with the passage of Amendment E, Judicial Accountability Initiative law members from across the country will purposefully drive to South Dakota just for the privilege of getting a traffic ticket so you can demand a jury trial. I anticipate traffic courts to be among the first courts to all but totally close." Granted, they are defaming the proponents of the initiative by accusing them of saying this. To that end, you may argue that they are not the ones saying it themselves. To that, my counter-argument is twofold. First, after poking around a little bit, I finally found the webpage on Jail for Judge's website where this passage appears. It's an archived blog post from November of 2004. However, there is one sentence near the top of this archived webpage that changes the entire landscape of this defamation. Here are some emails we received. That's right. The leaders of the Jail for Judges movement did not say this themselves. It's something somebody else sent them. But even if you take that out of the equation, my second counter-argument is this. The fact that the South Dakota Legislature included that provision in their resolution necessarily means that they believe its contents to be true, regardless of who the original author is. They nevertheless feel that this is going to be a necessary consequence of removing judicial immunity. Bear in mind, my argument in the documentary video about the lack of evidence still applies here. The South Dakota Legislature offers no evidence whatsoever that this consequence would in fact happen. But that's not what I want to talk about. As the title of this video shows, I want to talk about how they admit that the judicial system is entirely corrupt. Think about it. Why would a courthouse end up closing just because some people sued them? There's a difference between getting sued by somebody and actually being held liable for damages. Just like how there's a difference between being indicted with a crime and actually being convicted of it. So if people are actually going out of their way to get traffic tickets just so they can sue the traffic judge, why would the traffic judge care about being sued, as long as he knows he convicted the civilian fairly and according to the law? What reasonable jury would rule in the civilian's favor in that case? Well, I can only think of one way they could be justified in that fear. The only way this fear-mongering would make any sense is if they feared that a sufficiently powerful civilian, one with a sufficiently strong lawyer or a lot of political stroke in the community, would be able to manipulate the legal system to their advantage to get the jury to rule in their favor, or to get the judge in the corruption case to enter summary judgment in his favor, regardless of what the law is or what evidence he has to support his case. In other words, by the South Dakota State Legislature's own admission, the current judicial system is so corrupt that you don't need evidence, nor do you need the law to be on your side. All you need is the ability to butter up the right people, and anyone you don't like can be sued into bankruptcy or thrown in prison for years at a time without due process, simply because that civilian incurred the wrath of whoever happens to be in power at the moment. By their own admission, this is what the current judicial system is like, because by their own admission, that is what the judges would be subjected to if they were subject to civil liability the same as private citizens without any additional changes to the judicial system being made. So the question is, would this, in fact, happen to judges and courts if they were held accountable? No, I do not think it would. In the year 2008, a Cleveland, Ohio landlord was found by a judge to be in flagrant violation of housing regulations, subjecting his tenants to abysmal living conditions. In an act of poetic justice, the judge didn't fine the landlord or sentence him to a term of imprisonment. Rather, he was forced to spend 6 months living in one of his own decrepit apartments. This landlord later argued that the living conditions were so deplorable as to amount to a violation of his Eighth Amendment rights. You know, that constitutional amendment that prohibits cruel and unusual punishment. However, the irony of all of that is, by making this argument, he was essentially admitting that the living conditions he subjected his tenants to did indeed amount to a flagrant violation of housing regulations, something he previously denied. I suspect that removing judicial immunity would have a similar effect. By subjecting the judges to the same arbitrary legal system they have subjected private civilians to, they would subsequently be motivated to reform the judicial system on their own. No further voter initiatives necessary. However, if we use a voter initiative to prohibit judicial immunity, that means that these reforms that they create would be for everyone to enjoy. By forcing the judges to get down on our level, they would subsequently reform the system for us as well as them, so that they are no longer subjected to the arbitrary and life-destroying rulings of whoever happens to be in power at the moment. Maybe then, we'll live in a country with only minimal corruption. Maybe then, we'll live in a country where the law will be upheld regardless of whether any particular judge or prosecutor wants to uphold it. But until then, we need you to become active and start initiatives in your state. So please start those initiatives.